Welcome to today's program titled Navigating Marijuana Law for Employers, Compliance, Testing, and Policy Essentials. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Jen Mora. Jen, please go ahead.
Thank you, and good morning or good afternoon, depending on where you are dialing in from today. I want to thank you for taking time during a busy holiday month. I know everybody's unwinding, and so I hope that we can bring you some interesting information for the next hour. Again, I'm Jen Mora. I am in our San Francisco office of Seyfarth Shaw. I advise employers on drug testing and marijuana-related issues, also do some background check advice and counsel, and I'm here with my colleague Fritz Smith, who's in Atlanta, Georgia. He has very deep expertise in various labor and employment matters, but a particular expertise in drug and alcohol testing, cannabis, and is definitely our go-to when it comes to DOT issues as well. So next slide. Oh, we're there. What are we going to talk about today? We've got a lot to talk about. Again, we do encourage you to ask questions in the chat. If we are able to, I will either answer them throughout, I'll ask Fritz to answer them, or we'll wait until the very end. And if for some reason we can't get to your question, we will try to follow up with you after. But we're going to go through the current legal landscape. A big question that's been coming up for a lot of employers, particularly given some recent legislation in California and Washington, which is, what is the science behind marijuana testing even tell you? What is the utility? What is the difference in urine, oral fluids, and saliva testing? So we're going to spend a lot of time talking about that. We'll talk about what happened the last year. We'll go through some considerations for employers that are thinking about whether or not they should continue to test for marijuana. That's a question that we're getting a lot. Do we think that there's a trend? So we'll talk about that. And then we'll round out with discussion about some policy considerations. Next slide. So where are we currently? A lot hasn't really changed, but you can see on the next slide that Gallup is showing that every year, except for a small little dip somewhere around 2015, every year support for cannabis legalization increases. We are at an all-time high, currently at 70%. And I think that that's probably one of the considerations that goes into whether or not employers should continue to test. Are you having a hard time hiring people? Do you worry about culture, given that 70% of Americans support marijuana legalization? Next slide. So you've probably all heard that the Drug Enforcement Administration issued a proposed rule to transfer marijuana from Schedule I to Schedule III of the Controlled Substance Act. Right now, it is still illegal under federal law. With the switch in administration from President Biden to President Trump, we have no idea if that's actually going to happen. And I think a lot of the news out there with respect to this issue has quieted a lot. There is a lot that would have to go into this to make it happen. You'd have to get the FDA involved. You'd have to get the EEOC involved, since they, in their regulations, take a position about whether or not employers have to accommodate marijuana. And so until a final rule is published, which is not going to happen in the near future and may never even happen, again, it is still illegal at the federal level. It is a Schedule I controlled substance. But We are starting to, again, continuing to see a trend where states are passing marijuana legislation. Most jurisdictions do have it for medicinal purposes, and we'll talk about that. We're starting to see cities get involved as well. And given what we've seen in California and Washington, we'll probably see, and Minnesota, we'll probably see more states regulating the testing, because up until recently, there's been separate regulatory schemes. You have your marijuana laws, but then you have separate drug testing laws. So we're starting to see a trend where the law will actually address both issues, and we'll probably see that happen even more. I haven't really been seeing a ton of lawsuits out there. Fritz may have some thoughts on that, but we did see Massachusetts, a couple of other states, New Jersey, where we saw some lawsuits filed. Sort of seems to have quieted down, or maybe they're at least not making the public news. But we think that the way that the laws are written, there is potential for litigation to continue to grow. Those claims surround disability discrimination laws. So Massachusetts, for instance, while the statute does not say anything about accommodating marijuana use, the court, in the decision it issued many years ago, said that under the state disability discrimination scheme, an employer should, at a minimum, engage in an interactive dialogue. So that's where we're seeing courts getting involved in the issue, but they're probably going to start getting involved with recreational, and then again with California getting into the drug testing space, and also essentially making cannabis users a protected class, although they deny that. That's effectively what's happened. We'll probably start seeing more litigation there. Some places it's unclear whether there's a private right of action, and it can be really, really difficult. And Fritz will talk more about this when we get into whether or not you should continue to test, which is if you're a nationwide employer and you have a very large geographic footprint, how do you navigate complying with these laws? Because they're not the same. New York is wildly different from Nevada, and then you've got California, and then Minnesota, and they're just kind of all over the place. It's not like one state calls the other and says, hey, what are you doing? Let's do the same thing and make it easy for employers. So it's becoming a challenge for employers all over the place. Next slide. So this shows the jurisdictions currently authorizing medicinal use. Those states that are in, and you can see this is more than half of the states. Those in bold and underlined are those that where the state has granted worker protections, whether it be from a statute, from a case law, or from regulatory guidance. The jurisdictions, and what we see, and we'll talk more about this, what we would recommend in those jurisdictions, since there are worker protections, is considering engaging in interactive dialogues to determine whether or not you can accommodate. The jurisdictions with an asterisk, those are the ones where we believe there are what we call a safety sensitive safe harbor. So in Arkansas, for example, assuming that you're otherwise complying with the rest of the statute and any policy considerations, if you have somebody working in a safety sensitive role in Arkansas and they claim to be a medicinal marijuana user, then our reading of the statute is you would not have to go through that process. And there is only a handful of states where that is the case. You'll see Pittsburgh under Pennsylvania is a new city added to the mix. But we'll talk more about Pittsburgh as we make it along. Next slide, please.
Jen.
Yeah.
A couple quick points on our medical marijuana states, and these are issues that come up for both of us quite often. Why don't we have the District of Columbia and Michigan bold and underlined back on our medical use? Two reasons. As it relates to the District of Columbia, well, it looks like we do have it on our slide here, DC. I am of the opinion that the employment protections aren't effective in the District of Columbia because of a lack of funding in the district's budget for administration and enforcement. So I think there's a question as to whether those employment protections are in effect. If you read Michigan statute, it appears that there are employment protections in the statute. However, a Michigan Court of Appeals has ruled that there's no private cause of action under the Michigan law. We're starting to field a lot of questions about the city of Pittsburgh and what happened there in September. The city amended its code to include someone's status as a medical marijuana patient in its anti-discrimination provisions. So as Jen notes, as a general proposition in all of these states in which there are employment protections, you should engage in a dialogue with an applicant or an employee to try to determine if their use of medical marijuana as recommended by a healthcare professional precludes them from safely and effectively performing their job duties while engaged in lawful off-duty use of medical marijuana. Out of all of those states, we think that 23 of them have clear employment protections. New Jersey has its own special twist with some notice obligations. Feel free to reach out to us if you'd like more detail about any of the states and the protections that they provide.
Thanks, Fritz. And what do you, how does an employer, I guess one question that comes up a lot in the medicinal space, and we can spend a little bit of time on this, is that is it similar to the interactive dialogue or accommodation process you would go through, for example, somebody who, needs, I don't know, extra time off for anxiety or what have you? Like, what does it look like when you're specifically trying to determine whether or not to accommodate marijuana use?
Yeah, I think it's just a very simple conversation with the person and try to better understand how their healthcare professional has recommended that they use marijuana. At least 90% of the time, you're going to find yourself in a situation where you're talking with someone and they tell you, well, I come to work, I go home, I have dinner, I engage in the normal activities that I engage in at night. And before I go to bed, I take medical marijuana in the form that's been recommended to me to alleviate the symptoms of my underlying condition that qualified me to be eligible to use medical marijuana in the first instance. I go to sleep, I wake up, I don't use medical marijuana in the morning, and I come to work and I do my job. And in most instances, I think employers are going to find themselves having a legal obligation under these laws to allow the person to engage in that off-duty use and continue to do their jobs because they don't pose a true safety threat to themselves, to their coworkers, or other people at work.
Yeah, I think that's helpful. Okay. Next slide, we have recreational laws. This list keeps growing, not at the same pace as it was, I'd say, a year or two ago. I'm curious, Fritz, what, most of my questions come out of New York and California, but where are you seeing the most cause for concern, whether it's recreational or medicinal laws?
Yeah, it's New York, it's California. So you're spot on there, and we'll talk more about those laws. I get a lot of questions too about Illinois, and there's a lot of confusion even to this day about what the current state of the law is in Illinois. And I'm of the opinion that as long as you have a reasonable drug and alcohol policy, you can do whatever you want as it relates to individuals' use of recreational marijuana in Illinois, and that there essentially aren't any employment protections. New Jersey has confounded us for years. I'm of the opinion now that in light of a Third Circuit opinion that just came out within the past couple weeks, that there's not a lot to be concerned about in New Jersey as it relates to recreational marijuana. The Third Circuit affirming a district court in New Jersey came to the determination that there's no private cause of action for a violation of New Jersey's recreational marijuana law. And I thought before I read the opinion, well, why didn't the Third Circuit certify the question to the New Jersey Supreme Court for clarification? And the Third Circuit came that in its opinion said this issue is so clear cut for us that we don't even feel a need to certify the question to the New Jersey Supreme Court. So in light of that, I think that the protections in the New Jersey recreational law have essentially been gutted until a state court opinion comes out that might tell us otherwise.
That's interesting. Okay. Okay, well, now that we know the legal landscape, I'll turn it back to Fritz in the next slide to talk about the issue that has confused me the most until you explained it to me, which is the science behind marijuana testing. Let's go to the next slide.
Yeah, thanks, Jen. So I'm not going to get too deep into this because I'm not a scientist. As part of my practice, I had the privilege of talking with MROs, occasionally a toxicologist. But and this really all came to the fore with California AB 2188. Jen got wind of the law a couple years ago and sent the language to me and said, "Do you know what this means?" And I read it, and my answer was, "No, I really don't know what the heck they're trying to do out in California," which I don't think surprised us and probably doesn't surprise many of you. And the more we got into the language, the more I talked with people who understand the science far better than I do. We came to the determination that the folks in California were trying to get employers to focus more on the true psychoactive elements of cannabis, marijuana, and that primary psychoactive cannabinoid of the cannabis plant, as many of you know, is delta-9 THC. And once delta-9 THC is metabolized, THC is converted and stored in the body as a non-psychoactive cannabis metabolite, one of which is THCA. And urine drug tests, which have historically been the most common type of workplace drug test, target the THCA metabolite. And what does this tell you when you get that positive test result using urine drug testing methodology? Well, it tells you that somebody has used marijuana in the past, and it's either a function of days or weeks. But what it does not tell you is recent use and whether they're impaired at the time that they were required to submit to a drug test. As a result of AB 2188 and a similar law in Washington, we think that employers who want to continue to test for marijuana in those two states, again, applicants and employees in California, just applicants in Washington, should pivot to oral fluid tests, saliva. Those types of tests typically target the primary psychoactive element, THC. It tells you more recent drug use, but still, it doesn't tell you the exact time of use and when they are impaired. Next slide.
And I guess I'm just curious, one thing before I guess we talk about California and CBD, which is in the California law and the findings, they wrote that there are readily available tests to employers that prove impairment.
Yeah.
And is that true or false?
It's a great question. I don't think so. I know that there are vendors out there. Many of them have probably approached the folks who are on our webinar right now. I know they've approached the two of us, and certainly they've approached some of our colleagues too. And I think there was a basic misunderstanding in the people who wrote AB 2188 about the current state of the science. And no doubt, workplace drug testing, including the use of urine and other specimens, has gotten better. But I don't believe that there's a widely accepted methodology right now that proves time of use or more important impairment. And until the science catches up with the law, I have a hard time recommending to any company that they pivot to the use of a product whose manufacturer or salesperson is telling them that they can prove that, because we certainly don't have acceptance amongst the medical or science community. And until we get there, I don't think the legal community or the business community should accept some of the representations that are being made. And if you're willing to take on that risk, great. There are sound reasons why businesses take on risk daily. But just know that if you rely on such tests, there's a good chance you're going to be challenged. And as part of the challenge, each side's going to have a battle of experts about the reliability of the testing methodology. And most folks know that when you start talking about experts, you're going to make litigation, which is already costly, exponentially more costly.
Yeah. Okay.
CBD. Yeah. We could talk at length about this. You know, I'll try to keep this simple too. So CBD is derived primarily from hemp. And as some of you may have heard, there's another psychoactive element out there that is typically found in hemp-derived CBD. That's delta H THC. The FDA has done a very poor job of regulating CBD, and the manufacturers of CBD products have not done a great job universally of making sure that their CBD products have levels of THC that remain lawful under federal law or various state laws. And, you know, we know enough based on what's happened in your workplaces and the issues that have been surfaced to lawyers like Jen and I, what we read, that many CBD products that are out there contain more than 0.3% THC. And for me, it's this simple. People need to understand what they're putting in their bodies. They should not accept some of the representations that are made by manufacturers of CBD products and those people who are hawking them. And in your policies, I think it's simple as making sure that you have the appropriate definition of illegal drugs. Because if you do, I think it brings CBD and other products that have unlawful amounts of THC under the ambit of your definition of illegal drugs or illicit drugs, whatever term you like using. And if you simply state that illegal drugs includes cannabinoids and CBD and CBD products that include unlawful amounts of THC, I think that that should cover you if somebody tests positive and falls in violation of your work rules and you want to take whatever action you deem to be appropriate under the circumstances. Next slide. So we've already covered this in part. Next slide. But we'll talk a little bit more about the specific language in AB 2188. So the law became effective at the beginning of this year, and it now makes it unlawful under FEHA for most employers to discriminate against a person in connection with any employment decision if the discrimination is based upon one of two things: either the person's use of marijuana off the job and away from the workplace. Now, there's a caveat to that, which allows you to take action against applicants if you've got the right testing methodology that we've talked about. The second prong is focusing on your testing. And you cannot, in California, rely on test results that target the non-psychoactive marijuana metabolite. Next slide. So we recommend, if you're going to continue to test for cannabis in California, that you discontinue the use of urine and you pivot to saliva or oral fluids. And if you're using that methodology, then the law says that you can consider and take action, denial of employment based on a positive test result for cannabis. Employees, however, we think there is still significant risk based on the specific language of the law. And until we get some clarification from Jen, is it California Department of Civil Rights that enforces FIA?
Yeah, the Civil Rights Department, yes.
Civil Rights Department, yeah. Until we get some clarification, and I know Jen and I have been telling clients now for quite some time that we were hopeful that we get something, but you know, the year has come and gone and we have nothing. Or we see a court decision clarifying that language and perhaps suggesting that there is some level of action that you can take as it relates to current employees. We think that there's significant risk in taking action against current employees who test positive for cannabis, no matter what testing methodology you use. There's another part of the law that was recently amended that really falls within Jen's expertise, and I'll flip it back to her to talk about the restrictions now as it relates to pre-employment inquiries on
Yeah,
cannabis
it's
use.
yeah, it's poor drafting in my view, because the law says that employers can't consider any past marijuana use. And so if any of you are asking as part of your pre-employment post-offer background check process that have you been convicted of a crime question and you have a bunch of instructions, it would have been easy to say, you know, you can't ask about anything regarding marijuana possession convictions or marijuana use convictions. The law in California already does prohibit employers from asking about or considering non-felony marijuana convictions older than 2 years. But the way the language is written, it says you can't consider prior marijuana use. So it's a little odd phrasing, because how do you frame that except to say, don't tell us about anything regarding marijuana use? But that's just something to consider, that's out there. It didn't really seem necessary in my view, but that's just my opinion, which doesn't matter. One thing I wanted to ask Fritz before we go to the exceptions, which is I suppose the reason why it's risky to take action even against an employee, like let's say, for example, an employer has reasonable suspicion someone is high at work. If they send them for an oral fluids test, I suppose based on our conversations, the problem is that since it doesn't show impairment at work, and depending on the time of day you gave the test, they're just going to say I used the night before, and we have no way of proving they're wrong.
That's right.
I guess that's my problem.
Yeah, there's a close in time correlation to when an individual uses cannabis if you're employing the use of saliva and oral fluids. But unfortunately, they still don't prove when somebody uses cannabis or is impaired by cannabis use. And until the science catches up with the law, I think there's significant risk in California.
And we had an attendee ask about nail clipping tests, which I had never heard before. And I'm also curious about hair. Do those just go for the metabolites, or what's the science behind hair and nail clippings?
Well,
If you know.
I think hair could be an alternative specimen too. I think hair is a better testing methodology than urine in California, and is much like saliva and oral fluids. In all candor, I don't know much about the science behind the use of nail clippings, and I can't really speak to that right now.
I'll look it up.
I know that it's not a commonly used form of workplace testing.
Yeah, I had never heard of it until somebody asked about it in the chat. I thought, oh, that's a thing.
So next slide. And we'll hit this real quickly. Unfortunately, in California, as is the case with many of these statutes, there's no broad safety sensitive worker exception. We've got some limited exceptions in California. Employees in the building and construction trades, positions that require a federal government background investigation or security clearance in accordance with DoD regulations or some equivalent agency regulation, or individuals required to be tested under state or federal law and regulations. And the most common, as I'm sure most folks on this webinar know, are the DOT agency regulations that require drug and alcohol testing.
We're getting a lot of questions in the chat before we turn it back over to me about, well, what do we do with somebody that we think is impaired at work? Can we still test for other drugs? Is the use of the oral fluids that shows marijuana okay if it's coupled with strong signs of impairment, or should they just rely on the impairment? What are you telling clients to do in California?
Yeah, I think relying on the underlying indicia that lead to most reasonable suspicion drug test results, unfortunately, is still fraught with a lot of risk if you want to take adverse action. If you have extraordinarily strong reasonable suspicion indicia, one of the unintended consequences of this law and perhaps other laws across the country is whether you just don't even require testing and you act on the observations that you see. However, they really need to be strong. There need to be really strong, favorable facts for you. Those rare instances in which you actually see someone engaged in the use. Even every now and then we'll get admissions from people as a result of investigations. I just don't have any great news about the level of risk in taking adverse action in the most common reasonable suspicion scenarios right now, based on our understanding of California law. You can certainly use oral specimens to test for drugs beyond marijuana. I know some companies are actually using 2 specimens. They're using oral fluids for only marijuana testing and still relying on urine specimens for testing for other drugs. Was there another question there, Jen?
I was just smiling because it's such a dilemma and a conundrum. And I know you and we both get a lot of questions from clients that want great, amazing solutions that I wish we had, but we just don't.
Yeah, I think we got the solution for applicants.
Yeah.
But for current employees, I don't know that there is a good solution that exists right now.
Yeah, and I wouldn't anticipate regulations anytime soon, the way California, how slow they work with their regulation process. Their notice and comment period, they have hearings, and it's like on and on and on. And right now, California, based on, because I get the notices regarding proposed rulemaking throughout the year, and they're very focused right now on AI. And so I have a feeling they're just kind of, they're putting this on the back burner, unfortunately. And then a question we had, and we can go to the next slide because I can answer this question as we turn to Washington, which is, what about people who drive but they're non-DOT? California doesn't have an exception, a general safety sensitive exception, unfortunately, because again, they felt like there was a test out there that would prove impairment, so they didn't see the need for any of this. There is an exception for building construction trades, but then one question that I get a lot is, well, does that apply to people who are just walking around a construction site, or does it apply to people who are actually, with the hammers up on the high rises doing the construction? We just don't know because they didn't define it. So that's unfortunately. So yeah, no, there's no exception for even people who drive non-DOT in California. Okay. So we're going to go to Washington. Next slide. Washington essentially very almost identical to California, except it's only with respect to pre-employment. So you have to switch your methodology in a pre-employment context, and otherwise it's business as usual, whatever you're doing during employment. And the list of exceptions in Washington is far greater than in California. There would be safety sensitive exceptions, things like that. So in Washington, if you're considering cannabis, you want to, at least for pre-employment, move to the oral fluid saliva like we talked about. But if you want to continue to test for urine during employment, that's fine too. Next slide. Minnesota is an interesting one. So Minnesota actually has a drug testing statute. And when we refer to a drug testing statute, we're talking about a statute that talks generally about drug and alcohol testing, so would regulate all aspects of your drug and alcohol testing program. And some jurisdictions like Minnesota have very strict policy requirements and notice requirements. And you can have, I think it's, I can't recall off the top of my head, Fritz, one free alcohol positive or one free drug. Can you remind me? In Minnesota, I can't remember, but things like that.
The first offenders, right?
Yeah.
Yeah, I believe that extends to both alcohol and drugs in Minnesota.
I think Iowa, it might just be alcohol.
Yeah.
Yeah, so Minnesota is very, very heavily regulated, and this year they decided to amend the drug and alcohol testing in the Workplace Act, or what we call the DATWA, to provide protections for off-duty use. The law itself specifically bans pre-employment testing unless they're working in a certain role. Unfortunately, there is an exception for safety-sensitive positions. It also has modified the definition of drugs so that you actually need to modify your drug testing policy in Minnesota to make sure that you're clear that you're having essentially two different definitions of drug, or you have carve-outs for cannabis depending on whether it's pre-employment or during employment or the role. So it gets a little bit tricky over there. But other drug tests, again, business as usual. Keep in mind, we'll talk a little bit more about drug testing policy requirements. But Minnesota is one of the states that heavily regulates drug testing policies. And keep in mind too that Minnesota is one of those jurisdictions that does provide employment protections for medicinal users. So you'll really have to look at both the recreational side and make sure you have your testing protocol in place, but then ensure that you're also following the medicinal marijuana requirements in case somebody does test positive for cannabis in a situation where you're allowed to.
Yeah. And just so there's no ambiguity, I took a look at the statute and Minnesota does state that an employee may not be discharged for a first positive drug or alcohol test unless given the opportunity to participate in a counseling or rehab program. I also get a lot of questions about Minnesota and, is the risk real? And the simple answer is yes, it is. I've been involved over the course of my career in both single plaintiff and class litigation, involving matters where employers did not comply with DATWA. And, next to Maine, it's one of the most onerous drug and alcohol testing laws in the country. It's difficult to achieve compliance, but if you don't, there is risk. And the remedies in DATWA are similar to those that you might find in any employment statute. All forms of damages, including punitive damages and attorney's fees, are available to people who feel that they are aggrieved because of employer practices that don't comply with the statute.
Definitely nothing to mess around with in Minnesota. Next slide. So Pittsburgh, Fritz talked briefly about this one, but we'll talk a little bit more. So it's effective immediately. Pennsylvania already protects medicinal marijuana users from employment discrimination, but the Pittsburgh ordinance is a first of its kind. So like Fritz mentioned, they add cannabis users to its anti-discrimination scheme, but it also restricts employers from even testing those with valid medical marijuana cards for marijuana, except in very, very narrow exceptions. And I guess when I first read this, I was a little taken aback by it because, employers typically don't know somebody is a medicinal user until they test positive. You occasionally have a situation where somebody knows they're going for a test and they might say, hey, by the way, I'm a medicinal user. But I would say usually somebody doesn't make that claim until after they've tested positive. And so I guess I'm curious, what are we going to tell, the people on this call, and what are employers supposed to do? Are they supposed to now ask people as part of their pre-employment post offer, hey, are you a medicinal marijuana user? What do you think?
Yeah, I think so. I don't know how you comply with the statute unless you set up some type of a procedure to get that information.
Okay. And somebody asked for post-accident, sorry, there's a typo. It should be DOT testing, not DSOT. I will take responsibility for that. But someone asked in the chat about Pittsburgh post-accident, can you still test? I know that the ordinance refers to being able to test for suspicion of impairment. The problem with post-accident is you may not have suspicion of impairment, right? I mean, somebody might just crash their car and we have no evidence that they're actually high.
Yeah, that's a good question. I think that you've got some discretion to do reasonable suspicion in post-accident testing. But there is, it's not a black and white issue. I think random is problematic and is similar to the pre-employment testing.
Yeah, I agree. Okay, next slide. We just got a question about New York, so let's talk about New York. I'm not going to go too much into Rhode Island or Missouri. Fritz already talked about New Jersey. New York is an entirely different animal over there, and I know Fritz has some thoughts on it, but essentially, the issue there is it's legalized recreationally and medicinally, and the state legislature decided to amend the labor code to specifically call out cannabis in its off-duty protections ordinance. But then the Department of Labor went a step further and said, and oh, by the way, this means you can't test ever for the end of time forever unless you're in ridiculously narrow circumstances, not even safety sensitive, but obviously your DOT regulated drivers, but then government contractors if there's any risk of losing funding. And I know Fritz and I have kind of talked about this, which is we're not sure or don't think that the DOL's position is supported by the actual statute, but that's what they're saying. And who wants to get sideways with the New York Department of Labor, right? But I know that it's causing employers, I mean, worse than California, I think. Like we can't even test at all pre-employment, at least in California, as long as, they get their methodology correct, they can test. But I mean, what are your thoughts on New York? What's the big hoopla over there besides what I just said?
I think you said it well, Jen. I don't really have much to add to it. It's the greatest challenge right now on the marijuana testing front in light of the New York DOL's interpretation of Labor Code Section 201D. And until we get further clarification from a court or someone at the agency steps back from that position, I think it's a clear overreach. But it's all we have right now out there for purposes of assessing what the law means and the risk under it. And I think there's significant risk unless one of those narrow exceptions applies in testing employees for marijuana in New York.
Yeah, and somebody
I wish we could tell employers otherwise.
Yeah.
Particularly nationwide employers who want to try to have one standard, but
yeah. Yeah, and somebody asked in the chat, in New York, is there any guidance or experience regarding the meaning of articulable symptoms of impairment? And I'm looking at the DOL guidance, and there, of course, there is no dispositive and complete list of symptoms of impairment. Articulable symptoms are objectively observable indications that somebody's performance of the duties of the position are decreased or lessened. They don't say anything else beyond that. So what it smell and walking funny or the way their eyes look, like what do you think, Fritz?
I think it's all there in the guidance.
Fair. Fair. Do you think smell is enough to show impairment? at work? Because I get that a lot. I mean, I suppose like I had a situation recently where a client said that they could smell it coming out of the bathroom, and the person like there was one person who had gone in the bathroom and they had video that nobody else had been in there for an entire hour. And I get that question a lot. Do you think that the smell of marijuana is enough? And I always think, well, I walk through it in San Francisco all the time. I probably reek of it, and I don't use it, but I don't know.
Yeah, that's a great question. And I think it's an important factor in a reasonable suspicion determination. When it comes to marijuana, if that's all you got, I think you need to realize that your underlying assessment might be challenged. That's
I mean, as we tell clients all the time, a lot of this too is going to depend on your risk tolerance.
Yeah.
Right.
And for some clients, if we've got a strong odor of marijuana, then that standing alone may be enough to require someone to test. And your level of risk is going to depend on the jurisdiction.
Yeah, I agree. All right. Well, I guess that leads perfectly to the next question on the next slide, which is, should employers test for cannabis? And I've been getting, if we can go to the next slide, a lot of questions from clients about, do we think that there's a trend? And I'm not seeing a trend, but I know that you talk a lot with clients about, what they should or shouldn't be doing, or not should or shouldn't be doing, but what might work best for them. I'm just wondering, what are you seeing? What are thoughts? What are options?
Yeah, trend is a strong word, and there's not great data out there about what the business community is doing as a whole and what employers in certain industries are doing. You and I have the privilege of working with a lot of clients, and we know anecdotally what's happening. I can say that there are many employers, including some who I thought would never take this step, who are removing marijuana from their pre-employment testing panels because of the law and because of challenges in hiring people. Um, you know, a lot of that started in the pandemic, and it's continued. And if because of changing laws and changing norms and social mores, that more people are going to be using marijuana legally, whether it be medicinally or recreationally, you can't afford to disqualify such a large percentage of the American populace from your applicant pool. So we absolutely see a lot of folks taking marijuana off the pre-employment panel. Eliminating it entirely, not so much.
I agree.
Only testing for safety sensitive roles, yeah. We're starting to see more companies who place a premium on safety, but also are trying to counterbalance all of the legal challenge, all of the practical challenges, and saying, you know what, we're going to limit marijuana to those people who we know pose a significant safety concern in the workplace. We're going to limit it to reasonable suspicion context. We're going to limit it to post-accident testing context. We're allowed by state law. We talked about this in the context of talking about New York Labor Code Section 201D. If you're a nationwide employer, is there a one-size-fits-all approach? Unfortunately, no, because if you default to the most restrictive law, you're not going to test at all.
Mm-hmm.
And so I think the most common approach for organizations that have operations across the country is to adopt a state-by-state approach to all of these laws. And they will continue to test where they can test. They will continue to take adverse action in those states where there are not employment protections to people who are using marijuana. And in those states where it's clear that there are employment protections and someone either voluntarily discloses their lawful use or they take a test, and that comes up as the reason for the positive test result, then they'll engage in that accommodation dialogue that you and I've talked about, in which they try to better understand how somebody is lawfully using and whether that use is compatible with the job that they're doing, the job that they're applying for, and whether there's any risk to safety.
Yeah.
So the approaches are all across the spectrum. And I think we're going to continue to see that approach, because I do not think that there's going to be any changes at the federal level anytime soon. And this area is just like a lot of areas where there's lack of uniformity at the federal level. You're going to continue to see cities and states enact their own laws to fill the void. And they're not all the same.
Yeah, unfortunately. All right, next slide. DOT. I mean, I don't think much needs to be said about this.
Yeah, there doesn't. It's business as usual. It's a Schedule I controlled substance. It's illegal. You can't accept lawful use of marijuana as a legitimate medical explanation for a positive drug test result. So all of the consequences that may flow from a positive drug test result for marijuana under the DOT regs, under your independent authority as an employer, still in effect. You need to be cognizant of state law considerations, even in a DOT context, unless there's, some clear preemption. And that's going to come from the state law in most instances, but it's business as usual.
Okay. And then government contractors, next slide. I get this a lot. I'm a government contractor. I can do whatever I want. It's like, hold on, slow down.
Yeah, I think there's a common misunderstanding about the scope of any protections that an employer may be able to point to based on their status as a federal government contractor. We've talked about some of the exceptions to these laws, and that's certainly one. But as a general proposition, there's no testing requirements under the Federal Drug-Free Workplace Act or the state equivalents. And that in and of itself is not going to provide you with a safe harbor to do what you want to do in all circumstances. The best thing that anyone can do if they want to try to see if they can tap into their status as a government contractor, and there's not a clear exception in any of the laws, is to actually read the contractual language. And if there are some things that you can point to in the contractual language as it relates to testing, as it relates to actions that you must take pursuant to the contract, then those can be relied upon. But those issues, based on what has been shared with me from our clients, they rarely provide you with that safe harbor protection that you think they might provide you.
Yeah, I agree. And next slide. And I know that there have been some cases that have found for an employer and against an employer on that issue. So I think that future courts, though, will continue to say there's no conflict between you complying with both. So comply with both, but we'll see.
Yeah.
All right. I know everybody's been waiting for the CLE, and I want to make sure we get through the rest of this. So I'm going to go pretty quickly, but you can either scan the QR code or I'll read the CLE code, which is SS as in Seyfarth Shaw 1205, SS as in Seyfarth Shaw 1205. Okay, next slide, please. Drug testing policies, just real quick. And if you ever have questions about your drug testing policy, we're here to help. Next slide, please. But just keep in mind that, again, as I mentioned earlier, drug testing policies, for the most part, except in Minnesota, are separate and apart from the cannabis laws. There are a handful, I want to say maybe a dozen or so, what we call mandatory drug testing statutes. Those are the ones you have to follow if you want to drug test in that particular state. So you want to make sure you're mindful of them off the top. Minnesota, Iowa, North Carolina, Connecticut, Vermont, states like that have policy requirements. Fritz briefly mentioned Maine. For whatever reason, that state decided that before you test as an employer, you have to get your policy approved by the state. There's some hoops you have to jump through, employee committee, things like that. Make sure you have a clear definition of illegal drugs, or as Fritz mentioned, illicit drugs. You don't want an employee, if you're just referring to drugs, and you don't define what that means, and somebody to say, well, it's legal in California, so how could I possibly know that it was a violation of this policy? So we're a big fan of being very, very transparent and clear in your policy, so there's no room for wiggle room from your employees. California has a separate authorization for the release of medical information. It's the state that, of course, everything's different out here. They treat drug test results like medical information. So there's this wonky statute that requires you get an authorization for the release of medical info. And that form has to be in font 14. So make sure that you have that in font 14 and that you actually have that as part of your process. Next slide. And then one question we'll kind of round out here that we get a lot, and I do a lot of the background check advice and counsel, as does Fritz, but a big question that comes up a lot is whether or not your drug test results are covered by the Fair Credit Reporting Act, such that you have to follow the pre-adverse and adverse action process. And it gets a little complicated, but at the end of the day, it's really going to depend on how the information is reported to you from the lab. Is it coming directly from the lab to you? Is it assembled and merged into a comprehensive background check report? I see a lot of background check reports where the very last page of the report will have the drug test results. And if that's the case, you probably have to follow the pre-adverse and adverse action notices. If you're sending somebody directly to the lab and the lab reports the information directly back to you, that's not Fair Credit Reporting Act regulated consumer report. Keep in mind, though, this issue is separate and apart from notice requirements that I just mentioned might be required in a drug and alcohol testing statute. The other thing you're going to want to do with your vendors, based on everything that we've talked about today, which is if you're going to test for marijuana, then obviously you keep your panel that way. If you're not going to, do you get it removed from your panel altogether? If the vendor cannot remove the drug from the panel, do you have them mask it, or do you receive the information and just not consider it? I'm not a big fan of receiving information that you don't want to make employment decisions on, because then you have to fight about whether or not you actually made a decision based on the information. So if you don't want to know the information, try to work with your vendor to mask that information. I know that Fritz works a lot with MROs and labs and background check companies, and I assume that that's kind of the various options, which is to mask it or just pull it from the panel. But if you have any other real quick thoughts, we've only got a couple of minutes, I'd appreciate it.
Yeah, no, really nothing to add. I will say one thing. For those of you who are familiar with the Fair Credit Reporting Act, if there's any way to keep your drug and alcohol testing outside of the scope of a background check report and the Fair Credit Reporting Act and similar state laws, do it.
I agree. Because you're telling somebody they have the right to dispute the information, and it's like, well, with who? Who do they go to, right? And how do you even file a dispute over a drug test result? Because we typically don't give people another opportunity to retest. So it just causes a lot of confusions. Lisa, I see you wanted the QR code again. I'm happy to give that. It's SS Seyfarth Shaw 1205. And the next slide, I don't think I saw any other questions. I know we have 2 minutes, but one question that came up, because I know you talked about New Jersey, Fritz, which is, what are we seeing in New Jersey as to whether marijuana is included in the reasonable suspicion panel? I think you were saying, based on some recent cases, that we may be back to sort of business as usual in New Jersey, but can you clarify New Jersey real quick before we end this?
Yeah, I don't know that anybody that I work with has ever taken marijuana out of its testing panel in New Jersey by virtue of the laws. I think there's been some question as to whether the recreational law provides a private cause of action. I think we've got a clear answer right now that I feel comfortable recommending to employers that they can rely on. So I think your real risk in New Jersey remains compliance with the medical marijuana law.
Yeah, I agree. Okay. Well, that's all the time we have, because I didn't see any other questions. I tried to answer them as they came. It's good to see some familiar names and faces. And if you have any follow-up questions, please reach out to me or Fritz. We're always happy to help. And I hope you got something out of today's webinar, and we appreciate you attending. Thanks so much and have an amazing new year.
Happy holidays, everyone.